Good afternoon, everybody. I think we already have enough people for us to start the event. We have people here on our Zoom link. We also have some people watching us from YouTube. So I think that we can start off. First off, hello, everybody. My name is Samuel Oliveira. I am a vice president here of the Young Arbitration Practitioners Committee of the Brazilian Center for Mediation and Arbitration, or for short and much simpler, CJA CBMA. I am an intern here at Souto Correia, based in São Paulo. And the main goal for us, for the people who are not familiar with CJA, the main goal that we have as a group is to promote arbitration across Brazil and help prepare the next generation of professionals. And we do that by making a variety of events, whether they are online or they're also at places as well. We have a variety of subdivisions inside of CJA, which help us pursue our goal. We're also a group of younger people. We're mostly students and recent graduates from law school, which are interested in arbitration. So probably on this meeting, we have people who are earlier to the study of arbitration, people who are a little bit further out through their studies. Maybe they've already participated in moot courts. And the main idea that we had for building this subdivision of moot court competitions inside of CJA CBMA is because we've noticed how important moot court or moot style competitions are for the students and overall lawyers which work with arbitration throughout the world. And from that, we've created a series of events which we've carefully baptized with the name From Moot Courts to Real Life, which is a series that started about 2 years ago, which has a very simple idea in line with the principles that we have here at CJA, which is to bring the energy and learning from moot court competitions into the real world discussions. So to see how that truly applies to a real life scenario. And with that in mind, we have a very sensitive topic and a very great topic to treat upon this event, which is the cross-examination. For the people who have worked with arbitration before, I imagine that a variety of us have at least a little bit of familiarity with the theme. Cross-examination is very well used in international arbitration as well as national arbitration, and the Sciences Po Law School in Paris hosts a very important moot court competition, which is an international competition of specifically the topic on cross-examination. And today we have two specialists, I believe I can say, Miss Luísa and Mr. Tushar. Miss Luísa, just introducing them now. Ms. Luísa is a Brazilian qualified lawyer. She finished her LLM in Transnational Arbitration and Dispute Settlement at Sciences Po Paris. She works at Xavier Gagliardi Inglis in Schaffer, based in São Paulo, dealing with arbitration and complex disputes. And Luísa also competed exactly in the cross-examination moot at with the Sciences Po team and made it all the way to the semifinals, which says a lot about her dedication, her skill, and we're going to talk a little bit more about how that mood played a little into her career. And we also have an international guest here with us, an international speaker with us, Mr. Tushar, an Indian qualified lawyer with experience in major disputes involving sectors like maritime, construction, infrastructure, and telecom. Tushar currently works at Mundo in Paris, combining law and technology. He's also an advisory member of the FDI moot, which is a moot that I believe most teams might be a little bit more familiar with here back in Brazil. And he also acted as an arbitrator at the cross-examination moot, both last year and also this year, last week, as a matter of fact, as an arbitrator exactly for this competition. So I think we are in very good company here, two very qualified speakers. First of all, I would like to thank both Luísa and Tushar for participating in this event and helping us clarify and help talk a little bit more and introduce the cross-examination moot into the Brazilian scenario, which we believe it's very important for the formation of students as well as lawyers throughout the entirety of Brazil. So with that in mind and the opening being done, I would like to start with some questions. First off, to Luisa and Tushar. And I think we can go a little bit more for introductory questions, a little bit more about the context and introduction. So first off, I think we can go with a question for Luisa and then the same question for Tushar. I would like to know, how did you first hear about the cross-examination moot? How did you get familiarized with the concept, and what motivated you to participate, or in Tushar's case, to participate as an arbitrator as well into such moot?
I may go first. Thank you firstly for the kind introduction. I hope we can bring today some insights on the topic. So my first, I had never heard of this competition before here in Brazil. But when I arrived at the Cienspo, I was just arrived doing my LLM studies there. And as you all said, the Cienspo organizes the event. So the director of the LLM program, he wrote me an email asking, I think he knew about my past experience with moot competitions. So he wrote to me, Luisa, would you be interested in participating in the cross moot? And I was like, what is this? So that was my first contact with the competition. And then from then we created a team. The whole team was from the LLM program. All my colleagues, I think we were 5 on the team. But it started from the invite from the organization of the program, because he wanted people to enroll and participate. So we started with all the students from the program, and we had a really good experience there. It was a bit hectic because we were during our LLM studies, but it was very nice.
Tushar?
I can take it from there. Firstly, thank you so much for the kind invitation and the introduction as well. Happy to be here. For me personally, the Moot was launched in 2021, and I already graduated before that, so there was no room for me to participate. And in India, there's a very big mooting culture, and whichever moot, be it national or international, it is organized. We all get to know eventually, and it's like all the law schools create a roster of moots. So because the population is big, the law schools are big, the students are like in heavy numbers, and there's always a mood for everyone. So we were anyway aware about the mood that came in. But my first experience was in 2022 when I coached a team basically, and they went to the semifinals of the moot. And like I already had this experience of coaching at the cross moot. And then when I came to Sion's Po, obviously it was like a obvious choice that I should sit as an arbitrator. And yes, like as like Luisa, Professor Diego at our university, the director, he actually asked us of obviously who would like to participate. And but I was already like experienced in that regard, so I just sat as an arbitrator. And yeah, that's about it.
Well, that's amazing to hear. The main idea that we had for this event was primarily to try to bring a little bit more of the cross-examination moot culture to Brazil. As you both stated, as a matter of fact, both were invited from members of the organization, whether it was to act as an arbitrator, whether it was as a moody, and to actually compete into the cross-examination moot. So sometimes maybe being a little bit more distant from Paris here in Brazil, I don't think that teams have such contact with people from the organizing committee. So it's very nice to hear a little bit more on your experiences. And I think we can also get into our second question, and this also goes to Tushar. You told us that you were invited to arbitrate. Would you believe it's a matter of how qualified you were at the time, or the connections that you had because you already were a coach at the time for a team? What do you think led you to be invited, or the things that people who might want to get a little bit more relations with the cross-examination move, what would you say that made you get invited as an arbitrator?
Right. Thank you for. So basically, I did not do anything to get invited. It was basically the roster that the organizing committee also prepares. So just like any other international moot, if you're a coach, your name's gonna be obviously registered with the team. And if the team, of course, does well, they do maintain you in the roster. So when I came in, of course, I was already like invited to act as an arbitrator, and I received an email from the organizing committee. But in addition to that, there's always a registration form that you need to fill, nevertheless, even if you receive an email or not. And that registration form actually opens up like a couple of weeks before. So you need to just give your availability for the oral rounds. And I would also tend to say that when it comes to the selection for the arbitrators, just like in FDI Moot, you have a criteria for 2 years PQE. Basically, for this, it's basically a mix of experience and diversity, as well as like arbitration experience you have. Mostly, it's based in Paris arbitration sector, the industry here. And the Moots organizations definitely maintain a pool of practitioners and academics both, often from Paris-based arbitration circles and prior volunteers as well. So they eventually reach out ahead of the event to confirm the interest and availability first. And as I said, there's also a registration form that opens up a couple of weeks before. So for people who do not get invitation, they are of course open to register as an arbitrator. But from my experience, they already have a pool of arbitrators. So of course, they are given a bit of priority. Other than that, of course, it's an open invitation to everyone with experience in some sort when it comes to cross-examination. So I would say prior involvement in witness preparation, mock crosses, or evidence hearings, even if you have like experience related to dispute resolution in general. So of course, actual cross-examination experience is a plus, but not strictly required for the panels, I would say, because the panels are very diverse. And with the three-member tribunal, you always have a very senior practitioner, and you have a mix of a mid-level practitioner and a junior practitioner. That's always the case. So it's a pretty diverse panel.
That's very interesting to know how the panels are divided and how they get selected as arbitrators. Going a little bit more towards the teams in itself, we've heard a little bit more about the experience on someone who was an arbitrator, and I guess what we want to hear a little bit more is also from Luisa's side. You mentioned about the director sending you an invite, and you mentioned about a team of about 5 people. Was that team formed from scratch, or did you have a selective process sometimes that you had to participate in? Sometimes you already had a coach who was ahead of the program. How did that work to form that team to participate in the moot? Did you already know the people that you were going to get involved with, or was it a very big surprise that when you all got together, you discovered that there was about 5 people who were doing that with you?
I think in my case it was a different case because if I'm not mistaken, it was the first team to represent CINSPA. I don't know if that's correct, but I think so. So we didn't have any sector who organized the team or something like that. So with this other people from my LLM program, they also were invited because many of us had previous experience with moot competitions. So, but everyone was on the same page, like, oh, we just started this LLM program, should we enroll? But I remember once we were all together discussing if we should or we shouldn't. So we don't have, because in this, I think we'll talk about this further, but we don't have reading submissions. So, okay, we have weekly meetings to practice, and we are already together every day, all day. So I don't know, 1 hour a week or 2 hours a week. We take this time and we practice. I think we can do it. So it was a decision of the group. We were all invited, so we decided, okay, who wants to participate, and that's how we created our team. The only selection we have was to decide who was going to do the cross. Then we had these meetings and then divided the teams and who was going to do which side, the direct, the cross. That was the only selection we have made, but the team itself, it was a group decision to enjoy the competition.
That's amazing to hear, and congrats on being also one of the first teams to represent a very important school such as Science Po.
I don't know if that's a lie, okay? We have to check.
Yes, but definitely was one of the first. So
Okay.
at least that isn't a lie. But overall, you mentioned about that the cross-examination doesn't have a written phase. And I think this can go for both of you. How is the structure about the moot competition? Because here in Brazil, we have our national competition, which stems from the style that is the Vismut. So we have the written submissions. We also, after that, we have the hearings at which we do for 14 minutes, and then the other side gets 14 minutes. You get 1 minute for rebuttal, 1 minute for rebuttal, and then you go into the merits. So it's that very traditional moot style competition, and the way that the clock works and everything. How does the moot of the cross-examination work? Could both of you talk a little bit more about on that?
Sure, I can just give a brief. It's basically like a practice-oriented moot, so you could consider it like the next stage of the proceedings, post the opening submissions, and it's basically like you get about 50 minutes. If I'm not wrong, Luisa can correct me, and there's like an option to uh, have the chief examination, the cross examination. In both the participants, both the counsels get the option to do a redirect of the chief and the cross. So that's how it's conducted. It's usually the cross examination phase. Proceedings mirror like a hearing day. So the core is the direct and cross of the witnesses, and arbitrators are technically timekeeping, intervening, and catering to the objections.
As I remember, is 50 minutes, and you can allocate if you want to do the redirect. And they usually recommend you, I don't know as an arbitrator what you think, but the coaches usually recommended to do this redirect. So short, but they recommend it. So we usually did that. And I think that this part of not having the written submission for someone, for example, is thinking about joining a cross or any kind of moot competition, the cross is can be a first option because you don't have to worry about writing. So I think concerning timing issues, it can be you can accommodate this kind of moot competitions.
Well, that's incredible. And I think it leads us to our second line of questions, which is about the personal experiences that both of you had in the cross-examination moot. From what I understand, they were very positive overall, but I would like to go a little bit more about the challenges that both of you faced in the individual positions that both of you filled. So a question more directed to Luisa. What were the challenges or the biggest challenges that you found throughout the rounds? So was it time management? Was it more on a technical level? So how exactly would you do the cross-examination? Was it sometimes one of the witnesses who was sometimes not giving the or following the line of thought that you wanted? Was it the emotional control, the butterflies that we always get when playing the role of counsel in these sorts of moot style competitions? What would you say were the biggest challenges that you faced?
I think during the rounds, I would say it would be mainly technical issues like how to do it, because from my end here I had never had any kind of classes before that on cross examination, and I didn't take part in any cross in a real arbitration. Yes, in judicial proceedings, but it's a bit different, and I didn't have that much experience. So, and even though I did it, when I did it, I didn't know how to a line of questioning. I didn't know like the exactly techniques of what I was doing. So at this time, we practiced, and but I think it was the main point that I have to engage and practice with the team. And also this thing with the witnesses, because sometimes when you were arguing, you want to extract the most from the witness, and sometimes you can sound a bit aggressive. So I had this issue a lot. I remember one of the one of the members of the panel, they told me at the end, it was one of my feedbacks, that okay, you have this is a really good tip as well. I think we are going to get into this later, but know when to stop, because sometimes they are not giving you the answer you want, and you know they know it, but they are not giving it to you, and you start to pressure too much, and you can sound a bit aggressive. So as I can remember, this was one of the issues I had, and could be one of my biggest challenges.
I think from the small experience that I had in arbitration hearings, at which I had the opportunity to see cross-examination, I think that's a problem that many lawyers do go into, making one question too many. So you have that very perfect and amazing construction, and the witness is exactly going for what you wanted, and then you go for just that little question who's going to be the closing statement. It's going to make everything so perfect and so clear, and then the witness just goes all over the place. And I imagine it must be very tough to do that in a moot court situation. And I think that on that topic, Tushar, as an arbitrator, and from the other side of the table as well, from what Luísa told us, what would you say? What is like to arbitrate this cross-examination hearing? What are the sorts of questions that you ask the practitioners, the lawyers, or the counsels on such moot? And how exactly do you grade those people? Could you talk a little bit more about that?
Yeah, for sure. So basically, like sitting as an arbitrator, it's like a real life replica of a cross-examination. It's nothing different. The only different aspect is that the time is very limited and there are like 50 minutes. Usually in cross-examinations, it could go to like 3 or 4 hours in real life. So that's the major difference, and that's how we need to pose ourselves in the sense that we are running a tight hearing day. Basically, you're balancing like three things at once, keeping time, you're assessing advocacy, you're also discussing on objections with the tribunal members alongside. So there are like three things which you really need to take care of. You need to also see basically how the councils are reacting, in the sense what are their postures, do they have a right demeanor or not, are they speaking amongst themselves, are they disturbing the hearing in some sort of a way, how is the witness behaving. That's like really important. Although we are scoring just the councils, it's very important to see from both sides how is the witness actually behaving. So all of these things, we are like assessing all of these things. The rounds actually move fast. You never really get to know when it's finished. And I would say like from that experience, we see a lot of mistakes as well, and we see a lot of strengths as well. So for me personally, who usually what the councils do is like before explaining to the tribunal the topic or the aspect where they are doing the cross, they just start with the line of questioning, and it does not give any context to the tribunal. So this is where the tribunal is actually trying to find where the question is coming from. Although we have read the case, and the tribunal is being led through the documents, it's always difficult when the council does not establish things before like asking. So basically, it's about narrative, and that's like very much like non-existent sometimes. Then, of course, like there are a few strengths also that we see. It's basically like if the council, as I said, establishes a case theory before starting the cross, the questions are narrowed, the questions are targeted, and I mean, a lot of things come into play in this aspect, but it's like fun, like observing everything and trying to understand where the council is coming from. A lot, I mean, at least from my experience, within like 60 to 120 seconds, you can actually understand how the council is prepared. So that's like quite important. It's more to do with observational skills, I would say, because everyone's style of cross-examination is different, and we all do cross-examination differently. It's also to do something with how, what's your background, if you're a common law or a civil law trained lawyer, but you just really, it's more about observance, I would say.
That's very interesting to hear. Uh, we're both mentioning, both of you mentioned the idea of also doing the cross-examination to a witness that is going to be there at the cross-examination moot, right? How does that work? Is it the organization that also has a pool sometimes of arbitration practitioners that they decide that those are going to be the witnesses for that specific hearing or for that specific panel? Or is it people from the teams that get chosen as witnesses? How exactly does that play out?
They will be someone from your team. So the witness, you that's even funny because when you were practicing, one of the members of your team is going to be the witness. So that's why I said before. They know because they practice for it, and they know all the facts. And one of the it's a very important member of the team because they have to also practice and to escape the question. So. As well as we are practicing the cross, the witness is practicing how to run from some tricky questions, and it's very fun. I'm remembering right now, and it was a really funny moment because sometimes they create a lie. So because there's nothing in the rules that you cannot create lies, I think, because sometimes people do that. So it was very funny, and during the rounds you have to maintain serious because they are saying something really stupid, and you were like, okay, that's not in the case.
Well, that's very interesting as well because from some books that I've read before, they talk about the principles of cross-examination, and one of them is to not use the witnesses on the cross-examination as your weapons. So trying to use your witnesses to try to win over the case. And it's the cross-examination in itself is more of trying to reduce the damage that the other witness is going to have on your speech, on your case. And I think that that's a very good point because when you know that such witness has been throughout the whole process as a member of the team and they know all of the arguments that both sides are going to try to get through, I think it really goes to show the idea and the base of cross-examination and knowing that, okay, this person knows the case, they know the questions I'm probably going to do. How exactly am I going to be able to break the narrative that they're trying to construct? Um, that's very, very cool. I think we could go for one more question for the Tushar about personal experience. And I think this actually can go for both of you. Luísa, you mentioned a little bit about the experiences that you were remembering and how fun it was. What both of you would say is a memorable or decisive moment that both of you would highlight? So, Luísa, was it sometimes when you knew that you were going to advance into the semifinals, or Tushar, maybe you had to intervene into the hearing because one of the counsels was doing something which was completely outrageous? What would both of you say that was a very memorable and decisive moment for you?
I can take it pretty quickly here because it happened like last week and it was so funny. And it was basically as Luisa started with that, the coaches actually tell you to do a redirect. And I don't know what happened. There was this team which actually, and we just gave them time. We were like, okay, you have 7 minutes for the redirect, and this council was like blank and looking at us like, what am I being asked to do? And we almost laughed. We were like, okay, this guy is, I mean, clearly not in a mood. He's just here to visit Paris. So we asked him again, do you want to do it or not? And then this guy is like, okay, no, I don't want to do it. And I mean, he just let the witness go. So there was no redirect. There was no redirect, I mean, cross as well. And I mean, the round finished in like 30 minutes. So we were like kind of thinking in 30 to 40 minutes, what do we do? How do we score? Because in the scoring, definitely for the first council, if that council is just doing the chief examination, that council has just spent like 10 minutes and we don't know how to like actually score them. So it was quite difficult at the same point of time to score them, but very funny because then the other team was also not doing the cross again. And it was just funny, but we got free pretty quickly. So that was like very funny this time. And yeah, you never know like how teams come up. Some teams are just serious, some teams are not serious at all, and they're just here to visit Paris, I would say.
I think that just on top of that, before we hear Luisa a little bit, have you ever seen any team which was completely unpreparated, or that they were doing something? I mean, this is a clear example of a team maybe who wasn't really expecting the redirect. But was there any case that you saw that a team was clearly just maybe trying to fill a gap, or just sometimes trying to have a little bit too much fun, or that lost a little bit the hand and the seriousness that the mood proposes, as well as having fun, which is also the base of the mood court competition?
Yes, basically, there was one of the rounds again this year where I wouldn't say the counsels, but the witness was very, very funny, and the witness was just here to chill, in the sense that the witness was not at all happy to answer any questions, any basic questions that the other team was like posing to him. And his facial expressions and everything just seemed like he's not at all interested. He's just here to like run away after this. Although his counsels were pretty serious, but he gave an impression to us that he doesn't want to give away anything to the other team. The way he's reacting, the facial expressions, like he knows everything. Of course, like, I mean, a lot of these kind of things happen. And I would say sometimes the witnesses also get into the real role and they really feel that it's like a movie happening. It's like Suits, where, really you're having like a jury sitting, and you just need to like act and you need to win the jury. But that does not happen really in this international arbitration setting here in Paris, what we are replicating. And so, I mean, yeah, there was one of the witness like that, which was actually doing all of these things, and he was just looking at us and smiling as if like he's, winning his team. So occasionally these things can happen, I would say.
And Luisa, how about you? What would you say is a very memorable moment for you on the mood?
I think, as you all said, I think for me was the when we went to the semifinals, because the quarterfinals and the semifinals, they are at the ICC. So I was already happy to be there, doing the rounds at the ICC. So when we finished the rounds of the quarterfinals, we were all together waiting for who is going to the semifinals. And actually, we were not expecting at all to go to the quarterfinals or to the semifinals. So one day they said the CNSPO team went to the semifinals. We were like, okay, this is happening. And actually, I don't think we mentioned this before, but when you go to the quarterfinals and to the semifinals, the witness is not a fact witness anymore, is an expert witness. So you change the whole structure of the questions. So the game changes a bit. So it was really nice. This moment is it's a really nice moment that we had.
That's very, very nice. And it's nice to see how both of you very quickly remembered some memorable moments, whether it was almost coming close to winning the competition, or seeing sometimes a witness which is not that inclined to answering all the questions. And Tushar, I think this is another question for you. When you saw that witness, or overall, when you see a witness or a counsel which sometimes is doing way too many leading questions, or for example, witness who is very it's not very open to the questions. It's not going to help the flow of the hearing in itself. Does the tribunal actually get involved into maybe trying to talk a little bit to the witness or to the team? How does that take place? Or is it the arbitrators are there more to give grades instead of actually trying to interfere and guarantee the flow of the hearing?
Right. Basically, if the witness is being too adversarial, if the witness is being strategically evasive, and if it's being like strategically non-responsive, I would say combating or snowboarding, all of these things, this actually undermines the educational value and realism of the competition. And as like actual arbitration, witnesses who are evasive, argumentative, or performative typically damage their own credibility with the tribunal in real life cases. So this is, of course, noted by the tribunal as well if this is happening in the competition. And these witnesses being tactically obstructive rather than procedurally realistic, I would say, it defeats the purpose of the skills development in the competition. So I personally, I cannot speak for the other arbitrators, but I personally tend to interfere and ask the witness to be cooperative in this sense. If the question is of such nature that the witness should answer, and it's definitely the case when when the counsel is not attacking that witness. And I would say, I mean, this is also the case for the counsels as well. So there happens when the counsels have a lot of ego and they display a lot of ego. So in that sense, it is very important for the counsels as well to know how to cross, because there are a lot of common misconceptions students have and early stage lawyers have. I would say early stage graduates which participate in the cross moot, that they always they always fall into several classical traps, and they believe that they've like mastered cross examination. So for some counsels, there's always this idea that I need to destroy the witness, and the cross examination is all about aggressive confrontation and like Perry Mason movements, basically. And the aspect is the counsels do not cherry pick anything, and they just try to cover everything possible in their outline. So thinking that if I prepare a good line of questioning and stick to my script, I'm ready for the cross examination. So I just think that sometimes the tribunal members should intervene and see if the process is not being followed properly, because ultimately at the end of the day it's all about learning the skills, and if it's not being respected enough, then of course there's a room for intervention. And in even in real life, the tribunals interfere when the witness is not being cooperative. So yes.
Great. And you touched upon a subject which I think that leads us to the next point, which you mentioned about technique and knowing how to cross-examine. This is a question that also goes for both of you, and I think it's going to be very nice. And it's the concept of the event in itself to hear about someone who participated and somebody who judges the cross-examination in itself. How would you define a good and a solid cross-examination strategy? You talked a little bit, Tushar, about how sometimes you like to understand a little bit of the context, and also how sometimes you ask a question to a witness and the witness very well has to answer, or is a very good question that you would like to hear the answer, talk a little bit about it. How would both of you define a good cross-examination strategy?
I can start, and then Tushar, as the arbitrator professional, can make his points. I would say, firstly, this thing that Tushar just mentioned, that about the being aggressive, and I mentioned it before that I had this feedback. Because if you don't know how to ask your questions, even though you have good points, the tribunal is not going to listen to you, because you don't know how to make your questions. But firstly, I would say know your facts, because you have to manage how, as I said before, you only have to ask questions that you know the answers. So the only way to do that is knowing all the facts. And I structure that we did in the crossmood that I usually like to do is to divide in all the facts that are good for you and the facts that are not that good for you. Then you can have two lists of everything you have against or in favor. And another thing that Tushar mentioned is when you were doing the questions, dividing in, don't do only one line of questioning. You have to, for example, you have this. My case was a fourth runway that at an airport that they were constructing. So, and the other one, it was a corruption issue. And I remember some teams, they asked about both things in the same line of questioning, and it got really confusing. So as he well said, I think a good thing to do is divide the two topics into two different line of questionings, so it's clear for the tribunal where you want to go and what you're going want to prove. I think I know another really good tip is know where to stop, because as I said, maybe you are trying too much and you should have stopped it before. And maybe you already did your point to the tribunal, they already got it. You don't need to have the express answer from the witness. Maybe you have you got an inconsistency there or a contradiction there, and this is enough for the tribunal to start doubting the witness or challenging the witness, the credibility of the witness. So if you have this, if you are able to do this to challenge the credibility, I think that's enough. You don't have to have the express answer, so you have to know how and where to stop.
I can add on to some of the points Luisa mentioned, and I would just again start and reiterate that the strategy for an effective cross is basically deciding what you must win, how you'll win it, and when to stop. These three things, if you can master, then you can do an effective cross. So the thing is, for me at least, I belong from a common law background, and that's where aggressive cross examinations happen. And after coming to Paris, I realized that okay, not every cross examination should be like this. And of course, this is the way we are trained, and this is the way we do the cross. But for me, a good, strong cross examination strategy is just not a list of clever questions. It's basically an engineered plan which has like two to three critical propositions, combining the good and the bad facts, like Louisa explained, and using the witness as your source, very simply. So, um, the one point that I would like to highlight is the questions should be structured, and a tenet of cross examination is that you should only ask questions you know the answers to, like Luisa mentioned. And when you do, you can control a witness and force them to testify the facts beneficial to your client's case. But how you ask questions is also getting the answers you are looking for. So each question you ask during your cross examination should be a leading question, of course. Each question you ask should focus on one fact, not multiple facts, and you should be cross-examining witnesses about facts, not opinions. Opinions are pliant and differ from person to person, but facts are not, and facts are uncontested usually. So, one more thing also that I witnessed just this time, this edition, was that the counsels were not effectively using the witness statement, and we just felt like in none of the rounds the counsels were referring to the witness statement and just to the exhibits, which is, of course, fine if you're referring to the exhibits, but none of them actually read or like made the tribunal go through the witness statement. So that was very important. And I would also say that the students should be aware the differences between constructive and deconstructive cross-examination. And just to like briefly summarize this, when you're constructively cross-examining a witness, you are attempting to draw out helpful testimony from an adverse witness. So you need to be flexible. If the witness is adverse, you're going to do a constructive cross-examination. So the constructive cross-examination should feel like a conversation and not an attack, because if there are two attackers, if there are two bulls, it cannot be neutralized. So you need to take the pedestal and just lower it down. Mm, the cross examination should feel like a conversation, as I said. And the difference here comes like when you're deconstructively cross examining a witness, you are attempting to control an adverse witness and damaging their credibility. That comes into play when you are actually crossing an expert, for instance. And so that's the understanding that the teams should have basically. And yeah, that's about it. Like, I mean, there are many things that we can say, but these are usually the common things that students do not take care of, and they usually like go here and there in the cross, and the tribunal is often getting confused then.
I think it's very interesting as well how you mentioned the constructive and the deconstructive as well, with what Luisa said about how once you advance into the quarterfinals, the semifinals, you start getting a more technical witness instead of a fact-based witness. So I think it's also very interesting, or it might be very interesting to see in Paris, how that plays out and how different teams use these different strategies to the different steps that they have into the competition. Um, I think that we can also address a little bit more on the topic of the connection of that with real world practice. I think that maybe all three of us have already seen, and a variety of people here have already seen hearings and seen how a cross-examination gets played in real life. So how did you think that the cross-examination moot has contributed to the professional development, to your professional development in arbitration? So maybe Luisa, have you ever taken part in a cross-examination or cross-examined a witness? And Tushar, maybe sometimes you were into a cross-examination hearing and you saw a witness which maybe the skills that you acquired throughout the competition of knowing when a witness is a little bit more reluctant on giving the answers or reading a little bit about the arbitral tribunals or the council's faces and their reactions to the questions. How would both of you address how the cross-examination moot played a part in your professional development?
So in the arbitration hearings, I never did in real life the cross, but as I mentioned before, I did in judicial proceedings, and I think it's kind of similar, and I think it really helps. As I think as Tushar mentioned before, the time schedule and the organization is a bit different, but I think the technique it really helped. Especially because before, as I mentioned, I didn't study, I didn't know, okay, you cannot do open, okay, you will do that naturally, but you don't know, I didn't know the techniques, the exactly techniques. So it was good for me to come back and now, okay, every time I remember my coaches and I remember we had also classes with professionals from other law firms in Paris that they wanted to help. For example, from writing Pratt, I remember we had a lawyer from there. It was Tim Portwood. He was really good lawyer. He is really good lawyer, and he has really good techniques. And every time I remember about cross-examination, I remember about his comments because he's really concise and it's a very good lawyer. So I think these techniques they are the things that I can use now, and it was really helpful. And besides of this technical things, I think just for the connections you can make involving in this kind of moot competitions, any kind of moot competitions, I think this already has a really good impact in your professional life because you're going to meet people there. I don't know, from even in Paris, there are people from other places coming, and you can make networking, and I think this by itself it's good enough to help someone.
Yeah, I can add on to my experience. So I just feel that cross-examination definitely fills in a critical gap in law school education. And there's no moot like this. Basically, I do not know about the curriculums in Brazil, but in India, we definitely had a cross-examination capsule course in my law school, but it's not sufficient, I would say. Even though it was just limited to like cross-examining 10 minutes, just your classmates. It was not really as intensive as it should be. And the aspect is that I mean, I would say I was lucky I could do like two cross examinations all by myself with my partner sitting beside me, and he gave me the chance to do it. Just last year when I came for my master's, just before that, I did an arbitration hearing and I was doing that cross. But I mean, but the reality is that because of the cross moot, it fills a critical gap because young lawyers in international arbitration typically only get to practice cross examination many years into their careers. That's what I believe, and in real cases. And of course, because the stakes are so high, there's no room for error. even from even from like common law countries. There are like competitions called as mock trial competitions. We have them, but it's also a replica of the court, but not an arbitration. So ultimately, students and young lawyers are unfamiliar with the technique and particularities of cross-examination in international arbitration, which actually differs significantly. So as regards the skills, I would say definitely it goes for the arbitrators as well as students as well, because ultimately what we are doing is international arbitration in the end. And I would say case theory building is one of the skills, handling of evidence, time management, navigating exhibits, witness control, oral advocacy, procedural fluency, dealing with experts as well, in terms of navigating the quantum expert reports on methodology, factual assumptions, calculation for damages. All of these skills basically, as well as like active listening, I would say, for arbitrators, and professional restraint for counsels, basically knowing when to stop, like we talked about. So all of these things, I would say, are rarely taught in law school, and they come with experience. They come with a lot of experience to hearings, and for someone who just wants to know how would it feel like to be in the counsel's shoes and one day in a international arbitration seated in New York somewhere as a junior associate, it's the cross moot could give you that first mover advantage in order to understand how cross examination happens in real life.
That's very interesting. And also, you touched upon a little bit about the classes and the way that you maybe didn't have that much contact with cross-examination before you participated in the moot. And I think that it would be very cool for Luisa to touch upon this subject a little bit, about the actual contact that you had with cross-examination here in Brazil. Do you think that, for example, this moot is some sort of a supplement to the cross-examination that we already sometimes know and learn about at the law schools here in Brazil? What's your take on that?
I think it's a very different experience because, at least in my case, I didn't have much deep experience, and it was very okay. I knew what was the cross-examination because every know about the proceeding, but we had some mock ish during law school, but I think it's being there and you are being the one who has to put your face there and speak. I think that this makes you okay. Now I have to really know what I'm doing, what I'm going to say. So even though okay, in different places, depending on the place you study, you could have more contact with technical, I don't know, technical or maybe practical even. But I don't think it compares with participating in a mood, because only in practice, as Tushar said, only being there in practicing it, you are going to really learn it. So I think that's, even if you knew it already, it's important for you to consolidate what you've learned.
I imagine, from the past experience that I had in moot court competitions, I feel like it's very different from what real life is, because
Yeah.
there's always the aspect of the theatricality and always that the little spark, as Tushar also mentioned, of people trying to be maybe Harvey Specter from Suits or something. But definitely, I believe that even in those situations, for people who already know how to cross-examine or for people who are trying to learn, I think that the cross-examination mood might be a very interesting to learn and to consolidate the knowledge that they have or that they're trying to acquire, as a matter of fact. Going to the final tips and takeaways, and I think that we could continue this talk for hours and hours, but I also understand that Tushar is on a different time zone, so it's a little bit late for him. And still, what advices would both of you give to first-time participants? So if we fulfill the main goal that we have for this event, which is at least trying to at least just a little bit, trying to give a little bit more of knowledge about the cross-examination moot and trying to bring Brazilian teams outside of Brazil, maybe trying to go for Paris to compete into the moot. What advice would you give to these first-time participants who are interested in learning a little bit more about the moot and even maybe forming their own teams on their universities and participating?
I can go ahead. No worries.
Okay.
Uh, Basically, I would say, of course, go for it and absolutely, and understand that it's not a traditional moot. There are no written submissions, so it's actually really nice because drafting those heavy memorandums and in a tight deadline of like 2-3 months, and it's all about oral advocacy. There's no moot which could give you an oral advocacy time of like 1 to 2 hours. Even in Jessup, you get those 40 minutes, and in those Viz and the FDI moots as well. So, I mean, it's a different skill that you're trying to also master. So, no one is a master of cross-examination. It's just effective cross-examination. No one can be a master of it. So, it's a skill that you can practice in the early stages of your career. And this is the only moot right now, of course, in the heart of international arbitration in Paris. So, this is one way, as also Luisa mentioned, to network amongst arbitration practitioners, and you would see that there are no practitioners just based in Paris. There are practitioners based from London who come here, the practitioners based from Germany, everywhere. So it's not like you just are exposed to Parisian-based lawyers. It's just a really nice depth for networking. And for tips, I would definitely say like all of these things are really important. Like when you're like as counsels, you should not think about destroying the witness. It's more about like oral advocacy, mastering your case file in depth, including the witness statements, exhibits, preparing line of questionings per topic, but not like lengthy scripts and not sticking to those scripts. Studying real life cross examinations. You can always go to the ICSID website where the cross examination videos are like freely available and public, so you can actually see how the cross happens, and it's almost in sync with the real life. So all of these things definitely keep into consideration. And one tip is that for like starters, beginners, I would say just read the 10 Commandments of Cross Examination by Irvin Younger. It's like a starting point for cross examination.
I think Tushar covered it all very, very well. But the main point, I think, is do it because you're not going to regret it. Being there, you are going to learn everything, and all these tips you're going to practice with your coaches, and you only learn in practice, especially cross-examination. So if you're scared of, I don't know, I don't have time for it, or I don't know if I can do a cross or speak or I don't know, help my team with that. Yes, you can because you are going to learn while you are doing this. And regarding time, as I said before, this and Tushar mentioned it, this doesn't have reading submission, so you are going to make time for it. Like I did this during my LLM program, so you're going to be able to do it, and I think it's a really good experience that everyone has to take part.
That's incredible to hear from two very experienced speakers on the topic. Uh, I think we can go for audience questions as well. I think that we've covered mainly what everything that we wanted to cover, and I think that it was very clear how the cross-examination works. How does it play out into reality? How does it work in essence? And how is it to participate in both of you guys's personal experiences and personal views from the moot, which is also interesting that we have two different lawyers based in two different types of jurisdiction, and overall it seems like it was a a very positive experience for both of you. Um, I think we can open up to audience questions. If anyone wants to leave a question for our speakers on the chat or as well, we've put the forms from Google down at the chat, which also has a space for questions. So I think we can wait up a little bit on that. We have one question here from Rafaela, which she asked Tushar, what was this year's case about?
It's always like a construction arbitration. Basically, it involves like a number of issues. Sometimes it's like force majeure, sometimes it's like any kind of like routine construction issues like delays and everything. So it's always like construction arbitration, I would say, mostly. And the theme is usually different. Like it could be like hydroelectric power projects or something like that, but the issues remain more or less similar. And the issues as well this year were like concerning the delay, the quantum, so the two types of agreements that were there, and like multiple contracts having like different kind of provisions for the project, extension of time, delays. So all of these issues are actually recurring in every cross moot problem. And yeah, it was construction arbitration again even this year.
That's very interesting. And Luisa, how about you? Do you remember? I know it's been a while. I don't remember most of the moot court competition cases that I've participated in. So if you don't remember it, everything's okay. But do you remember about what was your case that you participated? You talked briefly about an airport or an airstrip. Could you delve a little bit more about that?
Of course. If I remember correctly, I think Tushar, you can correct me if I remember it wrong, but it was the construction of a fourth runway in a airport, and there we had so also construction, and we had delays. I think because of they needed this fourth runway, so it delayed other work. So there was a question of damages because of this delays. I think there was a point of on corruption as well because it was something related to ESG, ESG obligations because there was someone in the airport that tried to do in a wrong way to retain some certificates or approvals. So if I remember correctly, these were the main issues. But it was really interesting because it related both to construction and there was this corruption issue as well. So it was a really nice case. It was in 2023, right? The case of 2023.
Yeah, I would just add on that the case is like pretty huge. It's usually
Yeah,
like 300 pages or something, and it's not easy to digest. And for arbitrators as well, there's always an arbitrator's brief that's given because they know not many arbitrators would read the entire case. So, but as Luisa said, there's like an interplay of all the issues, and they always try to have a contemporary issue, a burning issue like ESG and climate change. All of these, even like after the ICJ's recent advisory opinion on obligations of climate change. I mean, these kind of issues are also covered, but as secondary issues, I would say. The usual aspect is like the routine construction issues only. Because in any event, you are cross-examining a fact witness where these secondary issues could come into play, but then ultimately for the advanced rounds, it's the experts. So it's going to be on quantum, the methodology for calculating damages. So this is pretty common.
I think you touched upon a very interesting part of what Luisa said as well, about how contemporary the topics are. We see, I don't know if both of you have the same view, but I see a lot of arbitrations that involve constructions that might have gone wrong, where the payment has been delayed, or the classic earn-out disputes, as well as disputes involving, for example, ESG, which about 2022, 2023 was a very hot topic as well. And I think it's interesting how the organization committee also takes that into consideration when making a apparently very big case regarding a dispute like that. We have another question about, and I think this might be a little bit more directed to Shar, but I think that it can also be extended to Luisa. about how does the evaluation of the teams work? What are the criteria, and are these criteria, and complementing on the question that was made, is this a criteria that gets just shown to the arbitrators, or is it something that the teams also have knowledge on exactly what criteria the arbitrators are going to evaluate the teams on?
Maybe like Luisa can also add on to this. I'm not aware if the teams actually get it because when the time I coached the team, we didn't receive any kind of scoring sheet. So this was back in 2022. But uh, for the first part of the question, basically relating to how you score, of course, there are parameters which is given in the scoring sheet to the arbitrators, and it's not like you get the scoring sheet on that very day. You get it like 2 days before. So you can, of course, go through the scoring sheet on what parameters do you need to do it. But what goes behind scoring is always the case that all the three members are aligned. In the sense, what we do is we deliberate just like any other arbitral tribunal would do. And in those deliberations, uh, personally, in my two editions where I've arbitrated, there haven't been a case where one arbitrator was not at all in line with the other two. And usually, that's the reason why they have a balanced tribunal with like a senior member as a president and two co-arbitrators just to have that balance. And I've always seen that during the deliberations, we always come to a common point and we also discuss the scoring as well. So it's gonna be usually the benchmarks that we are discussing that okay, this speaker was good in these aspects, so of course falls in the very good line category. So very good would be definitely 75 to 85, but in between those aspects it's up to the arbitrators. It's not like we're going to score 75 all across, but we definitely decide okay, this is the parameter in which all of us are going to mark that particular arbitrator, that particular council. So, I mean, I would say there are deliberations. It's not like the arbitrators do it in silos. I haven't like even heard about all of this that uh, the scoring varies so much. It doesn't happen.
Interesting. So you would say that sometimes the arbitrators would talk a little between themselves before actually starting to grade the teams.
For sure, for sure. It happens in all the moods as well as the cross mood. And actually, the deliberations can go up to 10 to 15 minutes, I would say. Like this time, it was about 10 to 15 minutes at least for both the rounds, because in one of the rounds, it was like both the teams were too competitive. Both of them were really good. And it was just like a 2 mark difference that we were like agreeing on that okay, this is something that we need to take care of. So it happens, and deliberations are usually there, I would say. Yeah.
If I just can add regarding the score, I received the scores from my team after the competition. So after we've done with the competition, we got the scores, but not during like after the panel or something like that.
Well, perfect then. I think we're gone a little bit over our what our schedule had in mind for us, but I think that it was amazing. It's very nice to have both of you here. I am so glad that both of you took upon the challenge to talk a little bit about the cross-examination moot and help a little bit not only the students and young arbitration practitioners that compose the group of CJA, but also everybody else who was watching us on YouTube, everybody who was aware of this from the posts that we did on Instagram. So I think definitely both of you have helped a lot to understand a little bit better about Moot. And who knows, and I really do hope that some members of teams would like to participate as well into the cross-examination Moot from what we've talked about. Because definitely it does seem like it's a very fun and very enriching experience for the people who participate in. So thank you so much, Miss Luisa, Mr. Tushar. It was very nice to hear both of you talk. I thank you both not only in the name of CJA, but also on the name of the team that had helped me put the event up. And also thank you, Tushar, for staying up late there on Paris, and Luísa also for taking a little bit of your definitely busy schedule to talk a little bit to us about the cross-examination moot.
Thank
Thank
you
you.
very much again for the invitation. And I open up if someone has any other questions, feel free to reach me out on Instagram, LinkedIn, whatever. I'm happy to help.
Likewise, happy to help. Just feel free to reach on LinkedIn and Instagram, whatever works. And thank you, Sam, for having us. Thank you to the committee as well. It's a real pleasure and happy to, of course, be a part of future events and support the initiative you guys are doing. It's a really nice job and just happy
Yeah.
to support always.
Thank you so much. I hope we get to see each other in person eventually, and eventually, who knows, even work together or against each other. That's a part of law, which is pretty fun.
That's the
So,
beauty of international arbitration. There are no borders.
Yes.
exactly. And thank you so much. Both of you are way too kind. It's very nice to have both of you, and thank you all for participating, and also thank to the listeners who are with us since the start. Thank you so
Thank
much.
you.
Thank you so much.
Thank you, everyone, as well. Bye.
Bye.